CLO of Ripple draws attention to three significant aspects of the SACV. Terra ruling. The chief legal officer of Ripple remarked on the outcome in the case of SEC and Terra, focusing on three significant aspects of the court's decision. Ripple's chief legal officer, Stuart Alderoty, has posted a remark on X, which was formerly known as Twitter, regarding the summary judgment ruling that was handed down in the lawsuit between the SEC and Terraform Labs. Recall that U.S. on December 28, District Judge Rakoff announced the much-anticipated summary ruling, which resulted in the Securities and Exchange Commission achieving a significant victory. The judge rejected the SEC's contention that Terra improperly marketed security-based swaps while simultaneously declaring UST and Luna to be securities. This was reported earlier. It is important to note that the SEC's allegations of fraud against Terra and its founder, Dokwon, will be determined by a jury in a trial that is set to take place in January of 2024. Several prominent crypto players and legal experts have expressed their opinions to the summary judgment verdict that was handed down in the Terra case. It is worthy of note that Ripple CLO is the most recent legal professional to offer their opinion on the topic. In a tweet that was sent out yesterday, the chief legal officer of Ripple underlined three significant aspects of the verdict. When it comes to legal cases involving cryptocurrencies, Alderoty emphasized the significance of having a factual basis. In his analysis, Alderoty made the observation that Judge Rakoff did not criticize or cite the decision that was handed down by his colleague, Judge Analisa Torres, in the Ripple case. Particularly remarkable is the fact that the Ripple verdict was not included in Terra's summary judgment, given the similarities between the two cases. Additionally, the Securities and Exchange Commission asserted that Ripple and Terra both marketed unregistered securities, while the judge who presided over the Ripple case decided that XRP does not qualify as a security in and of itself. Judge Rakoff decided that UST and Luna do qualify as securities. In the Ripple case, Judge Rakoff expressed his disagreement with the reasoning that Judge Torres had presented earlier this year. Judge Rakoff asserts that the Howey test, which has been used for a significant amount of time in the United States, does not differentiate between buyers in the same way that Judge Torres just described. Furthermore, Alderoty made a remark about the way the Securities and Exchange Commission controls cryptocurrency through litigation. Rather than having a foundation in solid policy, he characterized the Securities and Exchange Commission's fight against cryptocurrency as a fool's errand fueled by a hunger for political power. The comment made by Alderoty comes at a time when the industry is in the midst of continuing to struggle with regulatory concerns and drawn-out litigation disputes. Along with Ripple and Terra, the Securities and Exchange Commission is also engaged in legal battles with prominent cryptocurrency exchanges such as Coinbase, Binance, and Kraken. There were over 10 crypto assets that were classified as securities by the regulator in these proceedings. Since the Securities and Exchange Commission recently won its case against Terra, there has been an increase in the number of tokens that have been given the securities label. There's been a recent discussion among prominent members of the XRP community over the number of XRP tokens that have the potential to turn holders into millionaires in the years to come in the event that the asset reaches the crazily anticipated moon values. Within a recent post on X, the topic was initiated by Kenny Nguyen, an influencer who is in favor of XRP. Nguyen brought up the fact that he has been solicited numerous inquiries over the course of the years concerning the quantity of XRP that one must possess in order to achieve the position of millionaire. He restated his reaction, which has been consistent, and mentioned that 500 XRP can turn a person into a millionaire. Nguyen is of the opinion that an investment of $312 in XRP now has the potential to generate a profit of $1 million in the future. In order for this to occur, the asset would need to have a market value of $2,000, which would require a 319,643.7 increase from the present price of XRP, which is 6 cents. On the other hand, gives the impression that Nguyen's statement should not be accepted at face value. For its planned Bitcoin exchange traded fund, BlackRock has identified Jane Street and JP Morgan as permitted participants. The identities of the individuals who are going to be authorized to participate in BlackRock's proposed spot Bitcoin exchange traded fund were revealed on Friday, which is a major new piece of information. The asset management behemoth aims to engage JP Morgan and Jane Street as authorized participants. Friday filing indicates should the Securities and Exchange Commission obtain clearance for their planned fund. Authorized participants, often known as APs, are entities that are permitted to create and redeem shares of an exchange-traded fund. Alternatively, these organizations have the option of exchanging ETF shares for cash or exchanging them for a matching basket of securities that mirrors the holdings of the ETF. Watchers of exchange-traded funds such as James Sifart and Eric Balchunas, analysts at Bloomberg Intelligence, have been keeping a careful check on new S1s to see which companies are tapping which firms as APs. As one of the last steps before the SECO may make its decision, the disclosure is considered to be one of the final steps. In a research note that was published this week, Balchunas stated that the Securities and Exchange Commission was prepared to approve spot Bitcoin exchange-traded fund proposals that ensured cash-only creations and redemptions and had signed agreements with permitted participants. Both Balchunas and Sifart are of the opinion that there is a 90% likelihood that the SEC will let some companies to start a spot Bitcoin exchange-traded fund in the beginning of January. It is possible for the regulatory agency to make a decision on alternative plans that are comparable to the one proposed by ARK Invest and 21 shares before the date of January 10, which is the deadline for making a judgment on the proposal. On Thursday and Friday, respectively, ARK and 21 shares, as well as VanEck, completed the process of resubmitting their S1 documents. Nevertheless, neither company has identified any APS prior to the filing of the effective prospectus. Companies are not required to identify their AIPs. In essence, this means that they are able to go live. According to a statement made by Sifart in a post on X, and is under the accounts payable, conduit writer would theoretically have to be named along with fees and other details. According to a report that was published by Bloomberg in June 2022 and confirmed by a spokesman for Grayscale Investments at the time, Grayscale Investments was planning to collaborate with authorized participants, Jane Street and Virtu Financial, in the event that its Grayscale Bitcoin Trust, Gite, was granted permission to convert into an exchange-traded fund ETH in its most recent S3 filing. The company did not identify these businesses as permitted participants, and a spokesperson from Grayscale did not address any further questions or concerns. Those who are interested in cryptocurrencies and those who invest in them have had extensive conversations regarding the potential worth of digital assets, particularly XRP. Jack the Rippler, a well-known cryptocurrency analyst, recently made a noteworthy statement in which he said that a price of 1,000 per XRP is not very high. Because of the curiosity that this proclamation has generated among the crypto community, a more in-depth investigation of the reasoning that lies behind such a bold assertion has been prompted. Twitter was the platform that Jack the Rippler, a well-known and respected figure in the world of digital money, used to convey his point of view. It was highlighted by him that XRP should not be seen as a traditional share or stock, but rather as a utility protocol that is intended to tokenize value across a variety of markets, including derivatives and commodities. Utility and the ability to change the financial environment set XRP apart from other cryptocurrencies. Jack the Rippler noted that quadrillions in assets across marketplaces are ready for tokenization. He concentrated on the $500 trillion derivatives industry. That's all for now.